and people have noticed a particular trend where President Mohammed's lawyers seem to always have another application when an application is refused. Not everyone understands the application that they put before the court, but they know that the court's ruling on applications from Mr. Tsikata have always been refused. Some have taken the view that his applications are not well-founded. The partisan view from the NDAC is that there's something probably allegedly going wrong.
Well, of course, partisan view, we know that's what it will be. It will be a partisan view. The two sides, after every court, sitting, will have their views. But I believe that there are people who are discerning who don't even need a law degree to be able to tell that this particular petition may not be as exciting as the last petition in 2013. Now, of course, they had one application which was granted. The petitioners had one application.
I've forgotten that until you drew attention this evening.
And there was the erroneous impression at the time by the NPP group to suggest that by CI 99 you don't do amendments. Amendments are not allowed. The language of that provision says amendment that does not alter or change the grounds of the petition, which means certain amendments are allowed.
Yeah.
And that kind of amendment was allowed. Now, the judges gave a unanimous decision to grant the amendment. Since then, they have given unanimous decisions to dismiss applications and to uphold or deny an objection raised by Tsatsu against the Electoral Commission deciding that they also had closed their case and they were not going to call their witness. People have had issues and say, why are the judges in the first place? All the time it's unanimous. What is going on? They should be thinking differently. And when they have gone on review and there's 2 extra judges to join, still unanimous. And you have heard the propagandists play it out clearly to suggest that, this is rehearsed. And so you can't expect anything different. Now, from a purely legal technical point of view, this is how I analyze that. And it might explain a point you made into a question. If you say that I want to discover documents, that application was denied. If you say you want to discover documents, the Evidence Act, Section 166, says the value we put on originals is the same we put on duplicates. So if you have the duplicates, you must submit them because you can use them for the same purpose as the originals. If you bring an application in that regard, and the court said, you haven't shown us why we should compel the documents to be given to you from the original source. I hold the view that it is easy for all the judges to agree that you are wrong. And that's how come they are unanimous in that agreement. Why? Somebody will say, there's one particular document that they in fact didn't have, the Form 13. So that is a different matter. But in 2013, the same kind of application was made by Akufo-Addo, Bawumia, and Jacob Echebi-Lamptey because there were 3 petitioners. The new law rule has changed the game. You don't need 3 people, it's only 1 who must come. When they made the application, what did the court say? The court used the same law to tell them that this is a situation where you have the duplicate copies. All of them, all the pink sheets, you have them. So we'll use this law and use it to deny you. And in fact, you have brought the duplicates to the court. We'll use them because the law says the value we place on the duplicates is the same value we place on the original. Unless there's some other question about the integrity of what you have brought. In the 2013 petition, 9 judges, unanimous, they denied them the discovery. Except that when it came to writing their judgment, at least 2 of them regretted not allowing Afarijan to be compelled to bring the original pink sheets. Justice Doche and Akoto Banfo. They found that some of the pink sheets they had to rely on to write their judgment, some of them were not clear enough. Some of them had certain errors in them. So they themselves said it, that if they had the originals, it would have resolved this problem. But there were only 2.
Yeah.
There were only 2. So their decision doesn't even change what the unanimous had done. Now look at it from that perspective and ask yourself, has the court done something that's unheard of? Number 2, take the not allowing the one is the big
one.
Not allowing Jean Mensah to
That's the big one
testify.
the general public can relate to, yes.
Not allowing Jean Mensah to testify.
Yeah.
Well, the ruling came, and they took pains to take us through a lot of precedents to say that this has been the law. We do not find reason to change it. I'll be candid with you that even today, what they dismissed, I find that because they didn't grant that, and
because
then
they didn't grant the Jean Mensah.
Yes. And then refuse them the opportunity to reopen their case for the purposes of subpoenaing
The same
Jean
Jean
Mensah to come in. Today's review, even though they decided it on a purely technical basis, because the CI 16, which is the Supreme Court's rules, in 54, is very clear on how to invoke the court's review jurisdiction. It gives 2 major grounds: that there has been a miscarriage of justice as a result of an error that has been committed. So when you go to them, your focus of your argument should show the error and how the error has led to travesty or miscarriage of justice. Then the second ground is that you have discovered a new thing or important matter or evidence. Not that you have discovered it alone, but at the time that the court was giving the decision, which you are now coming to seek a review, through due diligence, you could not have discovered it, or it could not have been available to you. So it is a very narrow window that is exercised by the Supreme Court. So narrow, it is almost like I said somewhere jokingly, like the way to heaven. It's not broad. Now, Paul, look at it, and you know this. You see, at each step of the judicial process, there's an opportunity for a correction.
Yeah.
So the appellate process in the court, filing appeals, are all opportunities to do what? To correct
yes.
something that has gone on wrong. So if you went to the High Court, it will be a sole judge who will do something. If you are not excited about it and there is grounds for it, you go to the Court of Appeal. Then there will be 3 judges. They will review the work of that judge. If you still are not happy, you may go to the Supreme Court. You may have a panel of 5 who will now review that of the 3. Or you may have even more. Now, you know in law that litigation must come to an end at a certain point. It must not be in perpetuity.
Yeah.
However, for acknowledging that these institutions are manned by human beings and therefore error is possible, even at the Supreme Court, where everything should end, terminate, they have provided that extra window. It is the reason they have narrowed it so that we don't abuse it. Now ask yourself the question. You find that because they were denied that she will not be called, you will not open to come to subpoena. If anything else is done, there will be what you may call a certain internal judicial incoherence, inconsistency in the manner
on your screen,
in
though,
which
is Jean Mensah. Oh, they took it off.
in the
Jean
manner
Mensah was on your screen a moment
in the
ago.
manner in which the decisions have gone. They, at the first instance, they gave a broad, general application of the law, and they said, we are sticking with what is already there. That says a party or a witness who says, I elect not to adduce evidence, should not be compelled. Because, Paul, I've had the question.
But we want to know
that's the one side. That's the one side. See, if you took me to court, and made allegations against me, and we went to court, I could decide I don't want to come.
At all, yes.
You can get judgment in my absence.
In default of appearance.
And you'll be happy that I don't come.
Yes.
So it makes it easier for you.
Absolutely.
If I came and I delivered a defense or whatever it is response, and then we got to the time where I was supposed to get into the witness box, and I decided that I don't want to get in, once again, you should be excited.
Yes.
That, and you see, if I don't go in and do what I have to do, it may enhance your case.
Yes.
Right? But in this case, that's not what we are seeing. Here is what I find. The EC chairperson, questioning to answer, what does the petitioner want her to come into the box to do? Now, is it possible that the Supreme Court, which listed all the precedents, could also have given a certain exception? Yes, it is. Did we have some circumstance which they could have looked at to say there's the possibility of opening a certain small window for their application to carry? It is possible. But their decision was that we'll stick to what we know there is. And in fact, we are not granting you because you have not made the point out. You see, for example, when we're reopening.
So let me ask you, so if the Supreme Court had taken the second option, that let's allow a small window for Jean Mensah to come, even though it will be within their power to do so,
right,
would you have said they are taking the journey of a public interest instead of legal procedure? Pure legal procedure, will they have been infidel to the purity of Supreme Court procedure?
Right. So I've had a question about public interest and public accountability on the part of the Electoral Commission. And I've heard people even question some of us. They say, oh, but you RTI, you were the face of the RTI. We are asking somebody who said the documents can be available and now she's not giving it. And you are using your legal argument to say what the Supreme Court did, they did not breach any law. And so what? And I'm like, okay, so that's our understanding. Once you go to the courtroom, that's not where you make an RTI application. So don't bring in RTI and say, why am I an RTI advocate? And say that this is okay. So I'm saying there was, if they had giving room for an exception, and I found from my own examination that perhaps if I were a judge within them, I may have taken a view. that I will dissent. But you see, when you dissent, because there is a tradition, you must show
why you are dissenting,
why you are right. And then what you are doing, that's the point you're asking. Fidelity to what you call
the purity of the procedure.
Exactly. You must show why what you have done does not destroy
the procedure.
For
the future.
Yes. So I have been thinking about it. I hoped that at least one or two of the judges may have taken that kind of dissent and then offered me, the opportunity to learn why that dissent, was possible. But I come to the point that you cannot fault them for keeping to the precedent.
I get the point. Okay. Now, the final question before she comes in, and we're wrapping up. The fact that this trial has been put on public television, should that not mean that in considering the rules, we also consider the public interest part of it? Because not every trial is put on television. The courts hear several public interest matters. They don't put on television. Even the matters about voters register was not put on television. But this matter about electing a president, this is the second time we are putting it on television. As soon as we decide to put it on television, have we not, quote and unquote, included in the rules a certain public policy responsibility?
Public interest, like you may have come to know, is an unruly horse. And it is true that if there was anything like public interest, this is it.
Sure.
So I get to that point and say, the Supreme Court, if you like, is actually the true creator of precedent. In fact, it is not bound by its own previous decisions. So, could someone within the bench,
the seven,
have taken a different view? I looked for the opportunity to read a reasoned dissenting judgment that educates me on why they could have taking a different path, looking at the circumstances that have led to these various applications that are being mounted, all geared to get Jean Mensah into the box. Because I have not taken my time to look at the issue properly, to ask myself as a judge, how will I justify that dissent or departure and give it an exceptional circumstance without destroying what already is established in the rules?
That's interesting. Let me.
Yes, of course, if you went to the Courts Act, the Courts Act has provisions that empower the court to compel, a witness.
Yeah.
But you see, that is when they have gotten in already. You see, once they have not gotten in, they are not in.
Yeah.
And the rule says you can't,
I get that. I remember that.
compel them.
If she had come in and you wanted her back, it's easier.
When they wanted to open, I needed to just mention that when they wanted to open their case, sitting where I sat, I was looking for one major point that would have been argued. It wasn't argued. And when the judgment came, the ruling came, they mentioned it. So somebody I was in a discussion with called my attention. He said, you mentioned this, you said this was the most important thing to argue. And the court has mentioned it. They asked, what is the nature of the evidence
that you're looking for?
That you're looking for to bring in the person.
Yeah.
What is the nature of the evidence? So, if that question is asked, we will get to know whether the nature, that evidence you are seeking to bring the person in to deal with, is not already in, or it is in, but explanation is not sufficient. Therefore, there's a need to bring the person in.
Good. Final word, if you are on Jean Mensah only. Should she come to the witness box?
As a matter of public policy, but let me issue this disclaimer. I'm merely a student of law. And so I have no authority on this matter, except to say that the point that you raised, and something else also, are the public policy issues. I think that, and today I posted on my Facebook, so what is Amenuvo running away from? What are the EC lawyers running away from? They elected not to testify. I think that at this point, for the sake of what we intend to achieve, there's an end that we are seeking to achieve in this whole election petition, which is one of the reasons why we decided to bring the public on board in this matter and putting it on television and allowing lawyers as spokespersons for the two sides to even run commentaries on the issue. So for that very principle, put the EC in the box. And like Samson said, the petitioners themselves have a little difficulty in their issue. And one of the difficulties is what Samson was alluding to. What at all do they intend to achieve in putting the EC in the box? I do not think, in my respectful opinion, whether they have been able to prove that eloquently before the court, but that's a matter for the court to decide, which they have decided in the two rulings that they have given. But for the sake of public policy, and like Samson said, the court itself has had several occasions to distinguish cases. They can create an exception to the rules of the court. I was expecting the court to use this opportunity to create this window of exception, to create this window, given the peculiar nature of the Electoral Commission, the role the Electoral Commission is playing in the democratic dispensation, given the fact that elections of this nature have collapsed countries. For that matter, the court ought to create an exception to the rule and allow the EC to go into the box, even to force the court itself to use its own powers to force the EC into the box, because I understand that the court can do that. Yeah. I think the court ought to, for the sake of allowing...
The court can do that, but the rules provide basis for it. The question is, like in the Evidence Act.
Is that not the question is? Now, once you raise the Evidence Act, then there's going to be a conflict.
What do the judges themselves feel that they need from
the petitioners' lawyers,
that witness for which they should bring that witness in
to help them to write their judgment?
Yes.
If they don't see anything,
you, the petitioner, your case as you have made. So have you not heard consistently the petitioner say whether or not she goes in, our case is solid?
They've said that so many times.
So that was in the beginning.
No,
they still say.
So if you say that the question,
but we are not about. You see, we journalists are not about the case. We are about, you have allowed Ghanaians to follow this process. There seems to be an obvious question that everyone was waiting to see. The interview of Jean Mensah by John Mohammed's lawyers, so that we can all go to bed. Those of us who believe that she did the right thing, we can go to bed that there it is.
The questions have been answered.
She did the right thing. She didn't do anything wrong. She said she made a mistake. She corrected it.
Is it possible?
That's the end of the story. For us, it's not about legal procedure. We are not worried about that. If you wanted to keep the thing within the context, you should be worried
when you are in court.
Yeah, no, that's what I'm saying.
You are in court.
So it's a clear conflict between
when you are in
court,
public interest.
When you are in court, you are not in a newsroom.
That's the reason why you don't put court on television all the time, because the court of public opinion has its procedure, mental procedure, social procedure, which conflicts with that of the ones in court.
The respondents raise a preliminary legal objection, which means the petition could possibly have been terminated
at the beginning.
We believe that there was a public policy interest that allowed the court that let's go on.
Exactly.
It's the same thing.
Does the court have the precedent?
And the court itself raised the issues.
Does the court have the precedent of allowing matters to go on even where
absolutely they do.
And then they include it in their judgment?
They do.
So they do.
I get the point.